Today, we're diving into the really strange, really complex legal world of 0 days. You know, those secret software flaws that can be weaponized before anyone even knows they exist? It's a world where the law, well, it's always playing catch-up with the code. And this quote just nails the core problem, doesn't it? Technology launches like a rocket, while the law is, still trying to figure out how the car keys work. This isn't just some academic thought experiment. It's a super high-stakes mismatch with huge real-world consequences for everyone: researchers, huge corporations, and even national security. Okay, so let's make sure we're all on the same page. What is a 0 day? Well, think of it like a secret backdoor in a piece of software. And the name is literal. The developer has exactly 0 days to fix it once it's discovered and being used in an attack. The clock starts ticking immediately. So here's our game plan. We're going to trace the legal ripple effect of a single 0 day. We'll start with the actual crime, then we'll get into the murky gray area of security research. From there, we'll see the corporate fallout, and finally, we'll zoom all the way out to see the global chessboard where these little flaws become actual weapons. First up, the legal ticking bomb. This is actually the most straightforward piece of the entire puzzle. These are the laws that were written to criminalize the act of hacking itself. Yeah, you can think of cybercrime laws as blunt instruments. They really don't care about the nuance. They don't care how clever the code is or if the vulnerability was brand new. They are totally technology agnostic. All they care about is one thing: conduct. And that conduct is dead simple: unauthorized access. If you use a 0 day to get into a system without permission, you've broken the law. Period. The excuse, "but hey, nobody knew the door was unlocked," is completely irrelevant in court. The act of walking through that door is what counts, and that's the foundation of cybercrime laws pretty much everywhere. But this really simple rule creates a huge problem. And this is where the law starts to get very, very complicated. Because what about the people who are trying to find these flaws to make us all safer? And right here, this is the central conflict for security researchers. The things they have to do to find a vulnerability, probing a system, testing its limits, can look exactly like a malicious attack. Their whole intention is to help, but from a legal point of view that only sees the act of access, well, they can look like a criminal. So this is the million-dollar question, isn't it? If the very act of finding a flaw can be seen as illegal, how in the world can we possibly secure our digital lives? The short answer is, it's really awkward. In most places, there just isn't a clear legal shield for these good faith researchers. They're basically walking a tightrope, counting on something called prosecutorial discretion, which is just a fancy way of saying they hope a prosecutor understands what they were trying to do and decides not to press charges. New frameworks like the EU's NIS2 directive are pushing for clearer rules, but guaranteed immunity? That's still pretty rare. Okay, so we've seen the researcher's dilemma. But what happens when a 0 day isn't just found, but is actually used to attack a company? This is where a technical problem goes absolutely nuclear, right in the boardroom. And this is where the next legal wave comes crashing down. A technical vulnerability instantly transforms into a massive liability issue, and it's governed by really strict data protection laws like Europe's GDPR, which has pretty much set the global standard. Just think about this number for a second: 72 hours. That is the incredibly short, incredibly intense window that many companies have to figure out what happened, what data was stolen, and then report it all to regulators. The pressure is just immense. And that 72-hour clock? That's just the first domino in what can be a catastrophic chain reaction. The breach notification triggers regulatory investigations and potentially crippling fines. That, in turn, leads to intense scrutiny of the company's directors. And finally, you can bet shareholders might sue over all the financial damage. A single tiny line of code can unravel an entire business. And here's the crucial point. Arguing we didn't know about this specific flaw is not a get-out-of-jail-free card. Not at all. Regulators are going to look at your entire security posture. If your basic cyber hygiene, your patching, your monitoring, the whole setup was sloppy, you are still on the hook. All right, now for the final and the widest ripple. We're leaving the boardroom and we're entering the world of geopolitics. Because on this global chessboard, 0 days aren't just seen as code, they're considered weapons. That's right, the sale and export of intrusion software is actually regulated under international agreements, like the Wassenaar Arrangement. This literally places these exploits in the same legal bucket as conventional weapons. It's the world formally recognizing that code can be a powerful, controllable weapon. And you can see how this creates a fundamental tension, right at the heart of government policy. On one hand, you have intelligence agencies that want to find and stockpile these vulnerabilities to use for national security. But on the other hand, a government's duty is to protect its citizens and its infrastructure, which means getting those exact same vulnerabilities patched.
So how on earth is that choice made? Well, it happens inside these secretive government committees, often called a Vulnerability Equities Process, or VEEP. This is where officials literally weigh the offensive value of keeping a zero-day secret against the defensive need to disclose it. These are immense, high-stakes decisions, and they're all made entirely behind closed doors.
So, after tracing all of these legal ripples, from street-level crime to corporate law all the way to geopolitics, what's the bottom line? What's the one thing you should remember from this whole legal maze?
Well, the ultimate takeaway is this. There is no single law of 0 days. It just doesn't exist. Instead, these vulnerabilities sit at a chaotic, messy intersection of completely different legal worlds. You've got criminal law, data protection, corporate governance, and even international arms control, all bumping into each other.
Which brings us to the most important principle of all. 0 day does not equal zero responsibility. The existence of some unknown, secret flaw is never a free pass. It doesn't absolve anyone, not researchers, not corporations, and not governments, of their basic duty to be prepared. And this all leads to one final, really critical question. In a world that is completely built on code, the legal trend is crystal clear. You can't use ignorance of a specific flaw to excuse ignorance of the overall risk. Which really makes you wonder, is ignoring that risk the one 0-day vulnerability we truly can't afford anymore?